Welcome to VPG's Virtual Water Cooler Chat Podcast, a platform that features professionals across a variety of industries and promotes growth mindset principles with a central pillar of championing the achievements of women. Our conversations explore a wide spectrum of backgrounds, experiences, and perspectives, creating a vibrant mosaic that enriches our collective understanding and strengthens our commitment to growth and empowerment.
Today, Ashley is speaking with Aparna Watal, partner at Halfords IP Patent and Trademark Attorneys. Aparna is a highly skilled trademark attorney practicing in Australia and New Zealand, with extensive experience in advising clients on all aspects of trademark matters. She also advises on domain name disputes and is highly regarded for the commerciality of her advice and extracting the best outcomes for her clients in tricky and legally complex, contentious and non-contentious matters. Aparna's expertise extends to navigating the intricate landscape of Indigenous Cultural Intellectual Property, ICIP, where she collaborates with fashion houses and Indigenous communities alike. In addition, Aparna is speaking with guest interviewer Sarah Foley, a leader, a member, and a strong supporter of Adapt.legal. Sarah founded Foley IP Law in 2023 and leads a team of experienced attorneys and legal professionals with expertise in domestic and international intellectual property law, corporate transactions, and portfolio management. Sarah's team is committed to lifelong learning and growth, both personally and professionally. Together, they harness a spirit of curiosity to stay current on the latest industry best practices and deliver cutting-edge counsel to our clients. Let's get started.
Oh my God, how are you ladies doing? Happy Women's History Month.
Hi, doing very well, Ashley. How are you doing? Happy Women's History Month and belated International Women's Day.
International Women's Day yesterday. So I have a new friend to connect you with, Sarah Foley. Meet Aparna Watal from Australia.
Nice to meet you.
We are going to do a two-part interview today. I am going to do the first part, of course. And then after that, I'm going to turn the second portion over to Sarah. She is a woman founder of Foley IP Law, and she's also on the comms team of Adapt.legal, which I'm also on. And she's going to be asking you a few questions so she could actually help you share your stories to the Adapt legal community. Are you ready?
Yes, I am. Sounds wonderful.
Thank you so much for joining. It's been, a few months? I still cannot believe. I was talking, I think, to Olivia in the hotel lobby, and then you said, you were Ashley Chung. Look up. What did I do now? I sometimes don't know exactly what trouble did I get myself into. But you were so warm, and we had breakfast. We went to the Groombridge
reception. Yes.
Afterward, we got our Owala. So tell us about who Aparna Watal is.
Okay, so I am a lawyer, a solicitor, as we call them in Australia. I practice in trademarks law. I am a mother too. I've got two little ones who keep me on my toes. If I'm not negotiating on behalf of my clients, I'm negotiating with them. So my skills are top notch, I tell you, one of the hardest clients to work with. I also am a photographer, so I love doing photography. That's a secret passion, although since I've had my kids, I haven't really had any time. But that's Aparna in a nutshell, I'd say. An advocate, a mother, and a creative person.
You're also a chapter leader for the CHIPS Network,
yes, so
Australia and New Zealand, right?
Yes, that's right. So
among
CHIPS
other
Network,
organizations.
Yes, that's right. So I am the co-chair for CHIPS Australia and New Zealand. I used to be managing the events portfolio, but have now stepped into the co-chair role. CHIPS Australia and New Zealand, I would think we're still a fledgling chapter. So it's very much in the formative years of laying the foundation for the organization to grow. In addition to that, I'm involved in many industry bodies. I really like the idea of giving back to community. When I came into the profession, actually, I didn't really have any mentors from beforehand. So I had to find my mentors. I had to find my sponsors in the industry, and anything I can do to make it easier for the next gen, that's what I want to do. So I'm involved in organizations with a very heavy bend on helping the next gen coming through in any way. So I'm on the New South Wales Intellectual Property Society Australia of New Zealand committee. I'm involved with IPTA. I'm involved with many different organizations.
What made you decide that you want to go into IP and specifically trademark law?
Law, in fact, the seeds for that were planted quite early on in my journey, although my parents tried very hard to prevent it. When I was very young, I think I must have been in my early teens, I actually saw my mother go through a legal challenge. She was disputing a directive that was issued by her state university, and she took on her employer, which, was a big thing to take on such a massive institution. And I remember watching her lawyers argue such nuanced points and fight over interpretation and punctuation. You would think a kid could be turned off by that, but I was just absolutely fascinated by that. And one of the lawyers actually refused to take any fees from my mother because she was a teacher, and out of his respect for the profession, he said, I'm not going to charge you for taking on this case. And I think as a child, you see all of that, and that just, for me, it left a huge impression on me. I just thought, wow, law is truly a superpower. It doesn't matter how small you are, how limited your resources might be, you can take on any institution. So I think I told my parents from there on I was going to study law, and they said, absolutely not. I think I should take you back in time. In India at the time where I was, law was not the creme de la creme's profession. It was what you would do if you couldn't do anything else. And I was very talented at science and maths. So my parents are like, you're not going to study law. You're very talented. You're going to study engineering or do something else. So my father was a hard no with that. And so I decided, okay, you know what? I'm going to study engineering to start with and keep them happy. Plus also, I did enjoy understanding how things worked. I wasn't a pure science person. I was more on the applied sciences piece. So took on chemical engineering and started working afterwards as a chemical engineer and absolutely loved it. And that was the plot twist, because for a point I thought maybe this is what I'm going to do. I'm going to be a chemical engineer. But somewhere I think I began to get disheartened by seeing the underrepresentation of women in the engineering field. So I was working for a petrochemical company. So being out in the field, you'd be like one of two women in a group of 60 engineers. If you can't see others like you, it becomes harder for you to see your progression path, how you're going to make it there. And that's when the global financial crisis happened, which caused a lot of people, including me, to decide to return to university. And that's when I actually circled back to law. But I think having that engineering background, I knew going into law that I was going to be doing intellectual property. And I presumed with the engineering background, I was going to do patent work. So when I graduated, I took on an advisory role as a patent advisor in-house, thinking this is the perfect match. And it was a great learning experience, an entry-level role. But I think I quickly realized patents was not for me and in-house wasn't for me. So I took the first opportunity I got in private practice doing trademarks, and I absolutely loved it. Trademarks brings so many different facets of our everyday life together, and it's so much more fast-paced compared to patents. And I also think with patents, you kind of get confined to your area of specialization, working just within that field. But with trademarks, I could be working with engineering clients one day, which given my background is a great match. But equally, because of my creative side, the next day I could be working with fashion designers and startups or from all industries. So I just loved that diversity of work and the pace. Today, I lead the trademarks practice at Halfords IP. We're a specialist IP firm. We help companies protect their brands around the world, and we have a real expertise in helping SMEs, and especially those medium-sized enterprises who are taking the next step forward to go global.
Wow. When you said that you were a chemical engineer, that is a hard science. So I thought that you might actually go into the patent. So that's one of the things that I was really intrigued by, why and how you got yourself into trademark. And looking at your bio, you do represent and help with people that do fashion startup. So I thought that was really cool.
Yeah.
From a trademark perspective, how has AI complicated traditional ideas of brand protection, in your opinion?
I think with AI on the horizon, there's a lot of changes happening. But somewhere the fundamentals of trademark law haven't changed as yet. What I think AI has complicated in brand protection is the velocity at which things are happening, the speed and scale. And that's mainly because it has dramatically accelerated how brands are created and then being used. Traditionally, when a brand was being created, when it was being developed, it was a very deliberate process. It took time. Businesses would brainstorm ideas, engage advertising and marketing agents agencies. They would test ideas, and then eventually they would finalize 1 or 2 brand names that they would come to the trademark attorneys to clear and register. But now with AI tools generating brand options, logos, and taglines in seconds and at the scale of hundreds, I think that speed creates a real challenge for the trademark system, which is very much built around careful clearance and distinctiveness analysis. I think we're compressed for time, so it's definitely that sort of pressure that we're experiencing in the trademark system. I don't think the pressure has fully been manifested yet, but that's the direction, the early, seeds we can see of what's coming through. And I think another issue that adds that layer of complication with AI models, Ashley, is the enormous and not transparent data sets that these AI models are trained on, which often, as we know from the cases that are happening, from everything going on, they often include existing brands and marketing materials. And what that means for me as a lawyer and for businesses is that AI can very easily generate names or logos that are suspiciously close to real brands, even if
The
nobody in
likelihood of confusion.
Exactly. And you may not have the intention to do the copying, but it's not the subjective intention at play there with AI. It's just how it's built. You just don't know what it's actually leaning on in terms of the training material. So I think AI hasn't changed the fundamentals of trademark law. Brands still need to identify who's the commercial source of goods or services. So the function of trademarks hasn't changed yet. But I think with AI, brand creation has become faster, it's messier, and I would say even more riskier and conflict prone, when ironically good trademark strategies become more important now than ever before. The one thing I want to say is trademark law hasn't really been pushed to its full extent yet with AI, challenged to its full extent, but the one thing that we are yet to contemplate is how will agentic AI complicate this. I think agentic AI is on the horizon now. It's being developed. We've got that. And what I'm talking about right now, purchasing decisions are being made by humans, right? You want to buy a piece of clothing or you want to buy a shoe, you're the one who's thinking you're looking at the brand, you're looking at the product. But when you get your AI to do that purchase for you, how will we then assess the risk of confusion, the likelihood of confusion, as you said? Will it be different tests that would be developed for that? How is agentic AI being misled or confused? But then again, agentic AI is not looking at the sound, the look, and the feel of a mark. It's really looking at other parameters like the metadata and all of that background to a trademark. So I think that's something that's going to evolve over time, but that's where I think we'll really see trademark law being questioned, the basics of it, when agentic AI is the one making those transactions, those consumer purchases.
Can you give us a quick definition of agentic AI?
With AI in general at the moment, there are so many definitions floating around. So this is how I have understood it. And I think my definition and understanding amalgamates quite a few definitions out there, quite a few concepts out there. So I think the easiest way to understand agentic AI is it is an AI system that acts autonomously to achieve tasks, to achieve goals, rather than simply responding to prompts. So there is an action element to agentic AI. Right now, when you've got ChatGPT or chatbots, they're all reactive. So you put the prompt and they're reacting, they're responding to your prompt, and that's where it stops. The max task-oriented work that they do is to actually go find a link for you or find a web page or search this. Agentic AI, the idea is it goes further. You can actually ask it to go ahead and find what movie tickets are available for this date and this time in this location and go ahead and book them. That's the idea of being the agentic AI. It becomes an agent for the user to do those tasks. So it wouldn't just be about search the web for running shoes. It would be search the web for running shoes, compare and review prices, and order the pair and arrange delivery at a time when I'm going to be at home. So it knows where your schedule, it knows where you live. So agentic AI, that's what we're thinking it would be. It would be goal-oriented. It would be a tool used, interacting with softwares, APIs, browsers, and actually getting your tasks done.
Such comprehensive explanation. Thank you so much. You and I have talked pretty extensively about Tilly Norwood, the AI
Oh,
actress.
yeah.
Well, I saw your article, but that was not the first time I learned about Tilly Norwood. The
Yeah.
first time it was on my birthday. Of course, what do? I
Yeah.
do? I go to a conference. It's definitely not my type of conference. It's not a professional conference in that sense. It's organized by a group called Aspire Tours. It's basically like trade show. It came
Oh,
to my
okay.
attention because it has a few people that I really want to listen to them speak in real life. First one is Gary V. Gary
Oh my
Vaynerchuk.
God. Yes, me
I
too.
know. He was like flying into New York. I got half an hour for you guys sitting there and just like a whole bunch of stuff going on. And after this, I'm done. The second person is Kevin O'Leary, Shark Tank. And
Okay, yeah,
then
yeah,
the third one is at my lab, who's much more inspirational. But Kevin O'Leary, he talks so much about AI. So he showed us the
Mm.
different clips of one that is him talking, and then the other clip is AI generated. The AI generated one, it's almost flawless. He said that they're working on prototypes that will eventually be non-distinguishable. The real person will have probably more flaws, but they will
Yeah.
just perfect that. So that's when I first heard about Tilly Norwood. And then
Tilly
I
Norwood.
saw
Yeah.
on LinkedIn that you did an article about
Yes.
this. So you want to talk
Yeah.
about this a little bit first?
Happy to, but you know what he said about the prototype and there being very little difference between real life and AI generated. It's scary to me as well. If we begin to blur the difference between what's virtual,
In
AI
reality.
generated versus real life, I think that's a whole different level of complication. But as far as Tilly Norwood goes, so she, as you know, is a completely synthetic actress, completely AI actress. She's developed by a person, Eileen van der Velden, who is a creative person herself. She has a background in physics, as I understand, but she's very creative in the media space. And her production company is the one that developed it, Particle 6. Now, the interesting thing is we're all talking about Tilly Norwood, but she's actually not the first virtual actress, the synthetic actress in a way. I don't know if you've seen the Final Fantasy series. I haven't seen it myself, but when I was looking up Tilly Norwood, I found out that a character called Aki Ross back in 2001 was developed as a fully synthetic actress. The idea was that after doing that Final Fantasy series that she would do other ones as well, and that this would be like, an Aki Ross universe in a way. I understand that there's a hype around Tilly Norwood, but it would be inaccurate to say this is the first time we've had a fully synthetic actress. The interesting thing also in that is there's a difference in perception. So when Aki Ross was happening, when I was starting to do the research and was looking at media pieces on her around that time, there was a lot of curiosity and there was a lot of excitement about Aki Ross. Oh my goodness, what is it going to be like? How's she going to perform? But now there's a lot of negativity around Tilly Norwood. It's like that curiosity has died down because there is somewhere that fear of being replaced by AI. I'm not saying this is what it is, but perhaps, there's that fear. So that curiosity, unfortunately, has now given way to resistance to Tilly Norwood. That was just an interesting observation that I had from the research that I was doing. From a legal and trademarks perspective specifically, I think the first question is whether the persona, whether the actress, now whether that's a real person or a synthetic actress, whether the persona is actually functioning as a brand identifier. And so you see so many celebrities go ahead and register their brand, their names as trademarks. And that's exactly what's happened in Tilly Norwood's case. So we've seen that the filings have been done for trademarks around the world, in the UK, and I believe in the US as well, to register her branding, her trademark name. So in that sense, there's really not a significant difference from a trademarks perspective to the synthetic actress versus any human person, any human celebrity. The thing to bear in mind, though, with trademarks is that if a digital character is being used consistently to promote products or services, much like a mascot or influencer or a virtual ambassador, then their elements, the name, the stylized logo, all of that becomes associated with that persona, and that becomes not registrable because, they can use it for any products or services that they want to endorse. But there is a limitation around it as to what is the commercial intention to use it for, or what is the commercial extent of use? So for instance, with Tilly Norwood, the immediate commercial scope of use would be entertainment services. in class 41. But as she grows in her reputation and starts to do brand endorsements or starts to develop her own product line of clothing, then she could actually have protection for those goods and services. But that's how the business behind that virtual asset. So Tilly Norwood is a virtual asset owned by Particle 6, right? It would be about the business's intentions with that name, with that mascot, with that persona that they want to do. So I think with that, trademark protection would come into play. The more complicated issues that come up with Tilly Norwood are not so much in the trademark space. I think they are more in the publicity rights space or ownership space. Who actually owns the rights in Tilly Norwood? I mean, we've got the company with the Particle 6 on it with a big disclaimer on their website saying this is their asset and all rights and intellectual property is owned by them. But should it go to court, are they going to be able to establish the ownership? So that's a question. But those are very complicated questions that we're yet to see clear answers for. But as far as trademarks goes, I think it has not dramatically changed how real life celebrities versus virtual celebrities would operate or are operating.
I'm going to imitate this one. All right.
So distinctive. I know exactly who you're referring to and what you're referring to.
Matthew McConaughey, he actually had been talking a lot and he trademarked his voice and a lot of different things to protect himself from being taken advantage by AI. I think that there was some interview that he was talking about AI is not coming, it's already here. There's no denying in that. What do you think about actors taking a preventive measure by filing trademark on their voices and certain intangible assets?
So this is where I think everybody's trying to grapple with AI and they're trying to have as many options in their artillery to be able to fight it should it come after one of their distinctive attributes, be it their voice, be it one of their catchphrases, which is the case with Matthew McConaughey. Trademarks here, I don't deny that it's a powerful tool, but if we're thinking of it as a solution to the problem that they're trying to address, I think that's a mistake. I think there is a core function mismatch between what trademarks does and what it is being used to try and achieve here. So the fundamental challenge with using trademarks to protect personal attributes goes to the structure. Trademark law was designed to protect commercial source identifiers, what tells you where a particular product or service comes from. Who made that thing? Trademarks protect use of a commercial badge of origin. They are not meant to protect all imitations or misuse. And I think that's where the function mismatch comes. Trademarks is being used here or being seen as potentially a cure for a problem that it is not built to address. The second issue is, like I mentioned before, trademark protection is tied to specific goods and services. And that means enforcement depends on whether the use is occurring in a commercial context that causes confusion. To give you an example, if Matthew McConaughey's all right is registered for certain goods and services, let's say it's in class 41 for entertainment services, it's in class 25 for clothing, it's in class 9 for software and other products. If another person comes along and they use all right in a commercially completely different context, the trademark registration may not be able to come to save or take action against that user unless there is that possibility of confusion. So I think you'd have to, at least in Australia, look beyond trademark registration. We do have courses of action such as in passing off. We've also got what's part of the Australian consumer law, misleading and deceptive conduct. So even if that commercial use doesn't quite fall within the scope, the four corners of the trademark registration, if you can show that the phrase the alleged infringer is using has a reputation significant enough that there would be an association drawn, that there would be a misrepresentation to the consumers that that alleged infringer has somehow been endorsed by the source of all right by Matthew McConaughey, you could have causes of action under Australian consumer law and passing off. But trademark infringement is not going to give you a full solution. And I was reading when Matthew McConaughey actually got the registration, there was interviews with his lawyers who themselves acknowledged that, look, this is a punt. We're seeing how far can trademarks actually be used to protect against use by AI and that. So I think even they are cognizant of the limitations of trademark registration.
Aparna, you are a wealth of wisdom and insights. It's just so good to talk to you. On that note, I'm going to
Yeah.
pass it to my colleague from Adept.legal, Sarah Foley, so she could take on the next part. Sarah, are you
Yes.
ready?
Yes, I've just been fascinated listening so far to everything you had to say. My questions are kind of along the same lines and just a slight pivot, thinking from the perspective of businesses and companies that might not yet be thinking about AI risks and wondering what steps they should be taking to protect their brand, especially in light of, like you mentioned, the AI generated content coming maybe deceptively or confusingly close to existing brands, and even the use of agentic AI to perhaps create marketing strategies and what have you. So, what are the ways that you think businesses should be looking to protect brands in light of the quickly and rapidly expanding AI use?
Great question, Sarah. And I think we need to be having this conversation because what's needed first with businesses, in my observation, in the conversations that I've had, is a mindset shift. Most businesses, unfortunately, think about trademark protection reactively. They come to register their name and logos just when they're ready to launch, because they're going to launch, they need that protection sorted. Or they return to IP protection and trademark protection when something goes wrong. And those are reactive measures that could have saved the day previously, but I think AI really changes that threat profile as we've been talking. And in a way that makes that reactive posture genuinely dangerous. One of the ways that AI is a risk, and which is why businesses need to be aware and to be thinking proactively, is the impersonation that's happening at scale. And this happened in the past too. I'm not saying, impersonation is a new thing because of AI, but the scale at which is happening, the volume at which is happening, and the convincing aspect of it is so scary. So AI systems, I think, are able to copy so convincingly that they're creating a very high fraud risk. We recently had cases where clients have come to us, a completely unrelated website has created their business impression so realistically, copying the tone of the business, the messaging of the business, and everything, that if they didn't have their trademark registration sorted in place, taking action at that stage, especially if you're one of the SMEs where your reputation is there, but it's costlier to demonstrate reputation when you want to shut down a fraud risk like that for your business, it can be very challenging. In those cases, each of those businesses thankfully had the foresight to register their branding at the right time. So when it came to taking action against those fraudulent websites, we were able to take action quickly. They had a whole fraud ecosystem set up around those business websites where they had a corresponding LinkedIn page, corresponding many social media accounts. And the people connected to that businesses, the fraudulent businesses page on LinkedIn, were all employee names from the actual business. So if somebody had accidentally gone onto that fraudulent website, it would be very hard for them to discern that this is actually not the original genuine business. So I think that sort of impersonation, again, the Matthew McConaughey strategy, get the trademark registration. You've got one more thing in your arsenal to go after whatever problems AI might throw. If that's impersonation, you would be well prepared to tackle that in the brand space. And I think the second risk that businesses need to be aware of and need to take into account is the AI generated competitor brands. Generative AI is making it trivially easy to produce brand names, logos. The duping economy that existed, think of it as being on steroids now. And I think once again, because of that duping activity, we're already seeing an increased rate of activity, but I think that's going to go still higher. It's going to grow. Businesses need to be actively monitoring the registers and the market for any lookalikes. And I think the good part of that is with AI, we've also now got tools that make that monitoring easier. There are a bunch of tools out there. So I think, yes, AI is throwing those challenges, but the hope is that the AI is also giving us tools that we can employ to do better searches, to do better monitoring of the marketplace and catch those dupers early on.
That's a great point. The tool can be both something to be aware of from a concern standpoint, but also from a proactive use standpoint. And so, like you mentioned, there's an awareness gap there about when they should be looking at brand protection, trademark protection. Do you think that there is a role that professional organizations like ADAPT and others out there should be playing in making the trademark systems more understandable or more accessible for earlier awareness for businesses and professionals?
Absolutely. I think there is a role, and it's a very important role. And the honest answer, Sarah, there for me is, look, the trademark system is not well designed for people who do not already understand it. And that's where professional organizations like ADAPT, and we've got industry organizations in Australia, are trying to address that by explaining the system. But I think in addition to actually explaining the system, because of course more information is helpful, but I think we already have a lot of information out there. There are guidance documents and law firm explainers, and USPTO website tries to break things down for the self-applicants and for businesses. So does IP Australia and UK and EU IP. So I think organizations are trying to break down that information barrier and therefore help with access. But I think one thing everybody needs to consider and starts to work on is that redesigning of that entry experience. And one of the things I think organizations can work on is actually moving up the requirement for access to IP upstream into those really critical early decision moments. There's definitely information barriers that we need to break down. So providing access to information and therefore access to the system in a way, but also then providing at those key decision-making points, for instance, when you're registering a business name, that prompt, have you thought about the trademark registration, that very early stage. Really, when you are looking at your accounting software for your business is when you also need to be at the very early stage, need to consider the branding aspect, the protection aspect, the intellectual property protection aspect. So I think organizations definitely have that role to play to improve the information out there and provide access to that information, break the system down for people who are not already aware of it, but then also improve that entry-level experience and push that decision making, those prompts earlier on in the decision process.
That's great. And that's really what ADAPT is about too, is increasing access and awareness to IP systems like trademark systems so that people have that earlier identification and awareness in the process of who to go to and what to do, like you mentioned. So looking ahead, how do you think that the trademark law is going to evolve in response to all of these AI-created brands and personas and the issues that AI is raising within the trademark system?
I can give you a reasonable guess as to how that's going to pan out, but it's hard to predict the way things are going, what it's going to look like. At this stage, based on all the available information and the trends that we're seeing in the industry, I think color marks, which have existed for decades, but they've been quite niche and not as widely registered or employed. I think we're going to see an uptake in those. And I think they could even become mainstream or equally mainstream as word and logo marks. But the way examination practices have historically been for those kind of non-traditional marks has been very restrictive. They've been quite hard to register. So I think examination practices for those kinds of trademarks will need to evolve to handle that volume and to develop more precise standards for what level of trademark distinctiveness is required to register those kinds of marks. I think we'll see an evolution, but this is the prediction that I'm making at this stage based on the information, how quickly this field is moving. These predictions, may not actually turn out if something else comes on the horizon with AI. And the other thing that I touched upon previously was agentic AI. So how will concepts of deception and confusion emerge? AI agents may not perceive brands in the same way as humans do, who have been the source point for the assessment of confusion. AI agents may prioritize keywords and meta tags or recommendation rankings rather than brand reputation and the look, feel, sound of the products. I think we'll see an evolution as agentic AI takes hold, and this could take months to years, but I think as agentic AI takes hold, we could see a difference in how confusion and deception emerge and are assessed.
That's a really interesting point. If the agentic AI is confused, that might be the new threshold for confusion.
I think maybe we'll need to have two thresholds because humans will still be in play. So I think maybe it's really who is the consumer, but if it's agentic AI, then maybe a different threshold. But I think we're still quite early on. This is just my foresight, thinking how would it happen if agentic AI was doing the purchase? What would be the threshold for confusion?
No, that's fascinating. I don't have any other questions, but this has been a really insightful discussion. Everything that you discussed with Ashley beforehand and then now, I'm excited to see where we go from here and how the trademark law systems are going to evolve in light of the AI evolution.
Agreed. It's an exciting time. I'm one who embraces technology. I work with AI. And what I talked about changing that entry-level experience, I'm very much at the moment working on a platform to make that entry-level experience easier, user-friendly, and breaking it down for people who are repeatedly dealing with brands, marketing people, brand developers, businesses themselves. And I think all the organizations, and Adapt does great work at that. I think we have a role to play to make the new horizon with AI even more simpler to understand and less to be afraid of.
That's great. Ashley, do you want to come back on?
I'm back. That was such an amazing discussion. I learned so much and I always have such fondness, even though I only met her in October.
It's
Crazy,
only been
huh?
a few months.
So what have you been up to lately? I knew that when we were at Chips, you were like, oh, I'm gonna have to talk to Kathy. So did that breakfast actually happen? Right?
But Kathy's flight to Australia, so Kathy Vidal, the former USP Tour director, she was coming to Australia to give a keynote speech for one of the organizations that I'm part of. Because she's also a CHIPS member, we thought it would be a great opportunity for CHIPS members in Sydney and Melbourne and New Zealand when she's here, because she was going to do like a tour of all three places, for her to get to meet the local members. It so happened that when her flight to Sydney was horribly delayed, so we had everything ready to go, but she actually couldn't make it to the breakfast and she was very apologetic. It was sad that we missed out, but our Melbourne peers really got a great opportunity to connect with her and she is phenomenal. So post her breakfast with us, we actually set up a little WhatsApp group where she was connected with everybody. I think she is incredible as a leader, but also somebody who's so well connected on ground with everyone, so humble. She's amazing.
Awesome.
And I'm really glad we got to do that.
That's awesome. So what's on the horizon for 2026 for you?
So 2026, as co-chair for CHIPS Network, we're at that stage. We really need to have a rethink about the structure of the leadership of the overall national organization. So it's going to be a year to really set the stage for stability going forward. And of course, events on the trademark space in law in Australia, there is a lot happening. This Wednesday, we're getting a High Court decision coming out, which is going to shape a couple of key questions on trademarks law. And then we've got another decision due from the High Court. So we've been very busy in trademarks in Australia in the last year. And the High Court doesn't take on many trademarks cases. So we've had like 3 High Court decisions. High Court is the apex court in Australia. So things to bubble up all the way there, it takes a little while. But they've had 3 decisions. One came out in December, one coming out this Wednesday, and then the third one expected later in the year. So it'll be a very busy time because when the law changes or, clarifications come out, we've got to get that message out. We've got to work on it and really understand it for ourselves too.
And then, you know what? In June, you're going to be on our IP Talk Brand Insights live LinkedIn. And my cousin is actually going to be one of the panelists. And I've talked to her. Right now, her title is a draftsperson. I'm like, kind of a weird title, but she's not quite an architect yet. She has her master's degree, so right now her title is that. And I asked her, I said, I promote all the other young kids. What about you? She goes like, what about me? Do you want to go on live later? Actually, I don't know. I said, check with your employer first, because I don't know what they would want to do. She's like, I don't see why not. So she's going to get on. Frances Winkler Gutierrez, she is also an ADAPT member, I believe. She actually just finished a Harvard sort of a agentic AI data sciences course.
I think she'd be the one to give you the perfect definition for agentic AI then.
Okay, we'll ask her. I'll text her after this. I saw that on LinkedIn. I was like, oh my God, so that's going to be you, Melanie, and Francis, and I will moderate.
Yeah, no, looking forward to it. And I think by then we'd have these High Court decisions come out, at least one more in Australia. So it'd be interesting developments to report on.
Well, thank you. Thank you.